Penguin Random House Audio presents The Essential Scalia on the Constitution, the Courts, and the Rule of Law by Antonin Scalia. Edited by Jeffrey S. Sutton and Edward Whalen. Read for you by Christopher Scalia. With an introduction by Judge Jeffrey S. Sutton. Read by Jason Culp. And foreword by Justice Elena Kagan. Read by Karen Cummins. To Maureen Scalia. And when the last law was down, and the devil turned round on you, where would you hide, Roper, the laws all being flat? This country's planted thick with laws from coast to coast. Man's laws, not God's. And if you cut them down, do you really think you could stand upright in the winds that would blow then? St. Thomas More to his son-in-law, William Roper, in Robert Bolt's A Man for All Seasons.
Foreword. Justice Elena Kagan. In the 6 years Nino and I served together on the Supreme Court, I held to an unwavering rule. When Nino circulated a new opinion, I would put aside whatever else I was doing to read it. Whether I expected to agree or to disagree, I wanted to know immediately, not in a day or in an hour, but right now, what Nino had to say. I wanted to dive into his inimitable writing style, to marvel at the power of his mind, and most important, to take the measure of his ideas. I envy the reader who has picked up this book, as I once picked up those opinions, not knowing what he or she will find. Don't get me wrong. Justice Scalia's writings on the law wear well. They bear rereading and rereading again. As a former law professor, I read some of them a dozen times or more and kept seeing or learning something new. But in these last few years, I have missed the enjoyment and excitement, even the exasperation, that came from thinking about Nino's latest opinion. I doubt that anyone who turns the final page of this book will wonder why. No one has ever written quite like Nino, and no one ever will. He was a master of the aphorism, the analogy, the metaphor, the aside. His prose was simply ingenious, clever and pungent, pithy and sharp, plain-spoken yet utterly original. Judge Sutton, no mean stylist himself, gives some of the best-known examples in his introduction. The test that asked judges to figure out whether a particular line is longer than a particular rock is heavy. The problem with legislation creating a sort of junior varsity Congress. The interpretive rule that Congress doesn't hide elephants in mouse holes. And there are plenty more. The oft-interred doctrine that, like some ghoul in a late-night horror movie, repeatedly sits up in its grave and shuffles abroad. The First Amendment's prohibition of a statute that licensed one side of a debate to fight freestyle while requiring the other to follow Marquis of Queensberry rules. Maybe most famous of all, the counterpoint to the kind of constitutional peril that comes clad in sheep's clothing. But this wolf comes as a wolf. Line after line, it is captivating stuff, full of wit, dash, and verve. But the style was not for the sake of style. It was always in the service of ideas. Nino loved ideas. Thinking about them, talking about them, arguing about them, as well as writing about them. That love may explain why he found it so natural to befriend colleagues with whom he often disagreed. Yes, like me. Echo chambers, I suspect, bored him. It was difference of opinion that enlivened conversation, sparked debate, and created opportunities for learning. His love of intellectual exchange similarly accounts for his preeminent role in the court's oral arguments. When I was Solicitor General, I half dreaded, half hoped for questions from Justice Scalia. They were as hard as questions come, but also direct and fair, designed not to trip me up, but simply to confront me with whatever was the principal weakness in my position. And, for the most part, they really were questions. Justice Scalia let me respond in full and listened attentively to what I said. Once, when he had asked me a series of impossible questions, I asked him one back. A bad call. The Chief Justice rightly stepped in to remind me that lawyers don't get to put Supreme Court justices on the spot. But absent that intervention, I'm confident Justice Scalia would have answered the question, which was probably why I presumed to ask it. Decorum thus giving way to substantive debate. And, of course, that same kind of give and take could occur on the page. For all Nino's stylistic flair, the real strength of his writing, especially when he concurred or dissented, lay in its passionate yet disciplined engagement with ideas. Look for it throughout this volume. In sentence after sentence, paragraph after paragraph, Nino laid out, cogently, logically, with analytic rigor and precision, and, at times, with the elegance of a mathematical proof, deep and provocative understandings of the way the law should work. Read Mistretta. Read Morrison. Read R.A.V. I may or may not agree, but wow! It's possible that Nino wrote so well because he thought so well. And even if not, the main thing is the thought, memorable and lasting. I often ask myself how Nino would have reasoned through some legal problem. That exercise sometimes persuades me to come out the same way. Over the years, Nino convinced me of things I didn't first think. See, for example, Johnson, as I also did him. Not mine to reveal. But the Nino test makes my work better even when, or especially when, I wind up disagreeing. I discovered this effect early on, in my very first opinion. The court's tradition is that a justice's maiden majority be unanimous. But Nino thought that silly. What was the point, he asked me, as he pretended to seek my permission for his solo dissent, of a convention that shied away from, rather than delighted in, the clash of ideas? So I was forced to respond to Nino's incisive views on the car ownership deduction in bankruptcy law, and, in that way, to make my own argument tighter and more convincing. From that day to this one, I have written many of my opinions while imagining a miniature Nino sitting on my right shoulder. That Nino has never gotten me to pull my punches. To the contrary, he's led me, as the real Nino would have liked, to work harder and dig deeper, to search for the arguments that can withstand his mighty riposts, to plug every hole in my analysis that he so gleefully finds. Nino has upped my game as a judge. And I'll dare to speak for my colleagues by saying that Nino's peculiarly trenchant form of legal argument has done the same for the whole court. Even after his death, it rings in our ears. Most enduring of all will be Nino's views on legal method, and particularly on statutory and constitutional interpretation. To be frank, I don't buy them hook, line, and sinker. I share lots, but not all, of his statutory textualist commitments, fewer of his constitutional originalist ones. I spun out some of our similarities and differences when I had the honor of giving the Scalia lecture at Harvard Law School. Nino being Nino, he watched a live stream and sent me a long email afterwards to continue our jurisprudential conversation. But Nino's interpretive theories, communicated in that distinctive, vivid prose, have transformed this country's legal culture, the very ground of our legal debate. They have changed the way all of us, even those who part ways with him at one point or another, think and talk about the law. In reading a statute, Does anyone now decline to focus first on its text in...
Sample complete. Ready to continue?